Hello and welcome to AA Connect, the podcast of the Automobile Association of South Africa, where we discuss a variety of topics related to motoring and the motoring industry. We also touch on issues that are going to affect motorists and consumers at large. Very happy to welcome with us today Mr. Rob Handfield-Jones from driving.co.za, the Managing Director of driving.co.za, and somebody who is incredibly knowledgeable about not only motoring, but about legislation affecting motorists, about transport legislation, pretty much anything that has to do with the transport industry in South Africa. Rob knows everything about it, and one of the reasons why we got him to speak to us today. We are going to be talking about AARTO, and if you don't know what AARTO is, fear not. Rob is going to educate us. He's going to educate me as well. He does so on a regular basis. It's a great pleasure to have you with us today, Rob. Thanks for joining us, and apologies for some of the technical issues we had a little bit earlier.
No problem. Good to be with you, Layton.
Excellent, excellent. So, Rob, I guess the first place that I'd like to start is by asking you, what exactly is AARTO? Everybody speaks about AARTO. We know that the government says that they want to implement this AARTO system on the 1st of July 2021, which is a couple of weeks down the pipeline. But what exactly is AARTO?
The easiest way to explain AARTO is to talk about how traffic law is currently enforced across the majority of the country. And to start at the bare basics, all road traffic violations are criminal offences.
Okay.
They're contained in the National Road Traffic Act. And because they're criminal offences, if you commit a traffic violation, you can be taken to court and you can be found guilty and you can be sentenced.
Sorry, Rob, you can get a criminal record.
You can, yeah, absolutely, because it is a criminal offence.
Right.
So what AARTO intends to do is to take the majority of the less serious traffic violations and move them out of the sphere of the criminal justice system into an administrative sphere. So in other words, yes, it's still a criminal offense, but we're not going to pursue you criminally. What we're going to do is pursue you administratively. You will still have to pay a fine. And also there will be the concept of a demerit point system that comes in. So if you are a repeat offender and you continually offend, eventually you're going to accrue so many points that your license will be suspended. So it's a completely different way of looking at traffic enforcement without having to change the underlying basis that traffic violations essentially are handled as criminal offences.
So on the face of it, this is a pretty good system, right? I mean, I think in concept, this issue of a demerit system is something that the AA, for instance, has for a very long time, I think since the mid-1960s even, been an advocate for. Let's have a demerit system. So as you say, if you're a habitual offender on the roads, you get a certain number of points. And when you reach that maximum number of points, then you maybe have to go back to driving school or your license gets suspended until you are rehabilitated in some way. And so we basically ensure that people are following the law, and we are, in concept, ensuring that our roads are safer.
That's exactly what it's all about. And it's not a controversial system. Unfortunately, because of all the problems that have been swirling around AARTO, it's developed a bit of a reputation as a black horse. But that's not really the case at all. If you go and have a look at Canada, they've had an administrative system of dealing with traffic violations and a demerit point system since 1953.
Wow.
The US got it in 1957 or 1958. So it's not a new system. It has been trialed and proven to work elsewhere in the world. So I think really the issue in South Africa is how do we get it to work here?
And I think we've got an issue in South Africa in terms of the proposed AARTO legislation. And I know from the AA's point of view, we don't so much have an issue with the concept of AARTO or with the concept of a demerit system, but we've got an issue with what are the provisions of the proposed legislation and how it's going to be implemented. And I think you're on the same page in terms of those concerns, right?
Yeah, that's very much the case. I mean, I don't think anybody in their right mind would argue against more effective improvement or more effective application of traffic law enforcement. But we've got to look at how it's done. And one of the big issues is that it has taken so long. The first draft of AARTO started to be written in 1991. So we're talking 30 years ago.
Wow.
This is how long the government has been seriously involved with this.
Yeah.
The AARTO Act itself was signed into law in 1998. So there, 23 years ago.
Yeah.
The pilot project started in 2008, which is 13 years ago. So it's been a very long timeline. And because of that, there's been a loss of focus. And, 30 years is a long time in anybody's book. The civil servants who drafted the initial draft are all retired now. So I think from a government point of view, there's been a loss of focus and a loss of understanding on what was originally intended. So now the ground is starting to shift to what can be done with it now. And that's where some of the problems come in.
Good. So we've got a system where we're taking traffic violations out of the hands of the courts. We're making it an infringement. We're linking it to a demerit system. And the aim ostensibly is to improve road safety in South Africa and to deal with these habitual road traffic offenders. Has the system been trialed anywhere in South Africa? Do we know if it's going to work?
Yeah, we've had a trial phase in South Africa since May 2008. It was rolled out in a trial basis in Tshwane Metro and the Johannesburg Metro in Gauteng. And the objective obviously was to see A, if it's going to work, and B, if it's going to get any results. We are a very long way down the track with that trial period because it was supposed to end in December 2009 with national rollout following pretty shortly thereafter. But obviously, as you and everybody well knows, that here we are in 2021 and we're still in the pilot phase.
So 11 years later.
Yeah, the pilot has happened, but it didn't go according to plan.
Expand on that a little bit. Why didn't it go according to plan? What went wrong?
I think the basic problem was that the AARTO version that was implemented in 2008 was, in essence, a first draft. It wasn't an oven-ready product. And, when you're going to roll out a seriously impactful piece of legislation, you have to have an oven-ready product. You can't just put a first draft out there and say, well, guys, how does this work?
Yeah.
And that was revealed in some of the research that was done into the outcomes of the pilot project in 2012 and 2013. The government looked at what had been going wrong, and it was discovered that not only were the original stated goals of AARTO not being met, but there hadn't been any reduction in traffic fatalities either.
Wow.
And let's get back to basics here. Any traffic law or any system of implementing traffic law has to have as its basic goal reduction in traffic fatalities. If we don't achieve that, we're nowhere. So that's really what's happened with the pilot project. Because it was half-baked to start with, and because the improvements that have been made haven't necessarily been aimed at reducing traffic fatalities, it hasn't had the impact that I think a lot of people expected it to have when it was launched in 2008.
And you speak about this impact, and you speak about the fact that it has to have this element of reducing road carnage in our country. And from the AA's point of view, we consider this to be a national crisis. We're losing between 13 and 15,000 people a year to road accidents, to road crashes. And it's a huge burden not only on the families of those involved from a psychological and emotional point of view, it also has a huge impact on our economy. So anything that is going to deal effectively with road safety is something that I think you would welcome and we would welcome, and I think everybody in the country would welcome. But it's all about what exactly is that thing that is going to now bring better road safety to bear. And I think from government's point of view, they're looking at AARTO as being a silver bullet. But the message that we're getting is that the pilot that we've seen in Johannesburg Metro and in Tshwane Metro has not had that desired effect.
Yeah, it hasn't. And the words silver bullet are applicable here because that's exactly how it has been regarded, where in reality, it was never intended to be anything of the sort. Let me just wind the clock back to 30 years in 1991. At that stage, the Department of Traffic Safety, as it then was before the Road Traffic Management Corporation was formed, consisted of a lot of very technocratic, highly skilled people who'd done a lot of good things in road safety. They'd introduced national traffic legislation, because remember, before 1989, we didn't have national traffic legislation. The law changed as you drove from province to province. So you could literally, by crossing an arbitrary line in the sand, make something which was perfectly legal, suddenly illegal. So they fixed that. They fixed the problems of licensing with the introduction of the K53 licensing system, which was a real step in the right direction at that time. And we've got to measure those impacts by their results. And there were great results. Traffic fatalities fell in a straight line year on year from 1985 to 1998. So the whole purpose of AARTO was never intended to be a massive turnaround strategy as it's being pitched now by the government. It was intended to be an incremental strategy to say, okay, we fixed legislation, we fixed licensing, we're on our way to fixing enforcement in terms of capacitating traffic departments and so on. What can we do now? What can we add to this to make it even better? That was the original goal of AARTO.
Right.
And it has been turned around into, to use your words, a silver bullet. If we can just implement AARTO, suddenly the roads will be safe and it'll all be rainy unicorns and fairy dust. But that's not what it is at all. AARTO was never intended as the turnaround strategy, which it is now being pitched as. And I think that's where a lot of the problems have come in, because people are running around like chickens with their heads cut off saying, we need to do this, but not focusing on the end goal, which is, why do we need to do this?
You make a very good point. And I think when we look at something like, for instance, the Traffic Law Enforcement Review Committee, which was the committee established by the previous Minister of Transport, Dipua Peters, to look into traffic law enforcement, one of the things that committee found was that we need double the amount of traffic officers on South Africa's roads. And from a road safety point of view, that would seem like a practical way of dealing with that. Obviously, Rob, you and I have spoken about this offline many, many times, but we need a lot more pervasive education in schools, a lot more education campaigns around drunk driving. We need legislation that is impactful and implemented properly. And the message that I'm getting from you is that you have doubts that AARTO is that legislation.
Yeah, no, it is purporting to be something it was never intended to be. But to pick up on your point about the number of traffic officers, that's also not something new. When I was only starting out in traffic safety, that was a big point of discussion. I think at that stage, the estimate was that we had 11,000, the estimate was that we had 11,000 traffic officers in South Africa, where we really needed 25 or 30,000.
Yeah.
And that was back in 1990. So nothing has changed there. The big issue with enforcement and with resources is, how do you use the resources? So we should be looking at applying the traffic officers we have in the most effective way, rather than saying, well, what we've got now isn't working, so let's just double the numbers. Then we'll just have double the numbers of people being applied ineffectively at the taxpayer's expense.
Okay. You are listening to AA Connect, the podcast of the Automobile Association, and I'm joined today by Mr. Rob Handfield-Jones, and we're talking about AARTO, the administrative adjudication of road traffic offences. Rob, we've spoken about the context, I think, of AARTO and the legislation. Let's just kind of drill down and be very specific about this for a minute. I'm a motorist. I have absolutely no idea what AARTO is. How is this going to impact on me?
The end result is probably not going to be much different. If you got a traffic fine under the current means of enforcement, which is via the criminal justice system, you're still going to get that fine, but the process is going to be different. So nowadays, if you live in an area outside the pilot project, you will get a notice, which is to notify you that you've allegedly committed this offense, and you can, to use the phrase, you can buy your way out of it by paying an admission of guilt fine. And that's been, anybody who's been a motorist understands how that works.
Right.
However, if you don't pay that admission of guilt fine, eventually a summons is going to arrive, and then it becomes a criminal justice matter, and you're going to have to go to court.
Okay.
Under AARTO, you're going to get an infringement notice, what's known as an infringement notice, and giving you in the first 32 days the option to pay the fine for your alleged violation at a 50% discount. So if it's a 300 Rand fine, you can pay 150 Rand in the first 32 days. If you don't do that, then you're going to get what's known as a courtesy letter, which you're going to be charged for, by the way. So the costs start piling up, reminding you that if you don't pay this fine, doom is approaching. And if you don't pay that in a further 32 days after the courtesy letter, then what can happen is that an enforcement order is issued. And that comes with extra costs as well. So now your 300 Rand fine may have escalated to 600 or 700 Rand, plus a block will be placed on your e-Natus record, meaning you can't renew your driving license or licenses for your vehicles, and that will be problematic for you. So that is the process. It ends in an enforcement order rather than ending in a criminal conviction.
Just speaking of the costs, because I think one of the things that that has really concerned the AA is that you get an infringement notice for a figure of, as the example you mentioned, of 300 Rand. But in addition to getting that 300 Rand infringement notice for whatever violation you were alleged to have committed, you have to pay an additional 100 Rand infringement penalty levy just for the benefit of receiving that. Correct?
Yeah, that's absolutely what's being proposed in the 2019 Amendment Act to the AARTO, the original AARTO Act. And it's problematic for several reasons, but not least of them is that the penalty is the fine amount. In other words, if Schedule 3 to the AARTO Act, which contains all of the various infringements, says that the penalty is 300 Rand or 500 Rand or whatever it is, that is the penalty. Now the government proposes to charge you a penalty for paying the penalty. And if I can put that into simpler terms, it would be like SARS coming to you and say, okay, you have to fill in your tax return. You're required to by law. And by the way, it's going to cost you $100 to log into e-filing and do that.
Right.
That's the equivalent. So there is now a penalty upon a penalty. I'm not convinced personally that will pass muster when one of the court cases to challenge it finally gets to the Constitutional Court in Braamfontein. But firstly, I'm not a legal expert. And secondly, who knows what might come out of the courts these days, because there have been some strange decisions made about road traffic matters. But certainly from an administrative point of view and from a fairness point of view, there is nothing fair or just about that. And it looks like a money grab.
So you've got a fine amount on your infringement notice that says 300 Rand, but in actual fact, it's 400 Rand with the IPL added.
400 Rand.
Okay.
Yeah, that's
the issue that you're raising, and it's a very important issue in a broader context, because it really throws up two very important topics for me. The first is something that we've discussed about the rationale behind the implementation of AARTO, which is to drive road safety. Now, when we look at the provisions of road safety in the schedules of the AARTO Act, we see, for instance, you will be fined 3,000 Rand if you don't notify the authorities of a change of address, and you'll get 3 demerit points loaded onto your driving license. But if you don't have a seat, or you're not wearing a seatbelt in your vehicle, you only get 1,000 Rand fine and a 1 demerit point. So there is a bit of a disconnect in terms of, in our minds as the AA, in terms of the value amounts and the demerit points that are attached to certain offences, and the road safety offences seem not to be as prominent in terms of dealing with things that are bad, like not wearing a seatbelt or not having a child in a proper child restraint. Is that your take on it as well, Rob?
That's absolutely correct. I think if you go and have a look at the 2019 Amendment Act and you look at the updated Schedule 3, you can see without a shadow of a doubt that where revenue collection has been prioritized, or where it's been possible to prioritize it, it has been prioritized. And I want to wind this back to the general approach to traffic law enforcement. It all starts with collecting data. If you have data on how your traffic is behaving in a certain country or region or area, you can then say, all right, this is all happening at the taxpayer's expense, because all of the structures that make it happen are structures of government. So we need to provide value for money to the taxpayer. And that means we have to say, where can we get most bang for our buck? In other words, where can we reduce fatalities the greatest amount for the least spent? That's how traffic enforcement should be prioritized. They should be taking that data and saying, well, the data clearly says that head-on crashes, for example, are the biggest issue. They cause the most fatalities, and the interventions are the cheapest. So let's send all the traffic officers out and start enforcing overtaking at blind rises, blind corners, barrier lines, and so on.
Right.
You get your bang for the buck.
Yes.
But if you go and have a look at the data on how traffic violations are divided, how many of the infringement notices that are issued are for those, there's a huge skew in favor of infringements, which are easy to police and highly profitable.
Yeah.
Whereas if you look at things like drinking and driving, which we know is a massive problem,
Mm.
there are about 500,000 infringement notices issued a month, and less than 1%, 3,000 a month, are for drinking and driving. So there's a total disconnect between the impact of drinking and driving, which is known, it's been studied, it's well understood, and the way that it's policed. And it comes back to the fact that it is very difficult to get a conviction for drinking and driving. And even if you do get the conviction, the fine revenue to the state is going to be minimal versus setting up a speed camera and just going click, 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 click. So the revisions to the AARTO Act very much support the click, click, click approach rather than supporting the let's get dangerous drivers off the road approach.
Yeah, I mean, you speak about this issue of drunk driving. In the current legislation, you get 60 merit points before your license is suspended for a period of time. When you're back again, you get another 60 merit points. But you've got to go through a whole process. And in terms of AARTO, it's not necessarily going to take drunk drivers off the road immediately. Instead, they're going to have another bite at the cherry over a period of time, in terms of which they can still be drunk driving. So it's not necessarily going to take them off the road immediately.
That's absolutely correct, but it is no different to how things currently are, which comes back to the point you made much earlier about AARTO not being a silver bullet.
Yeah.
AARTO was never designed to solve our drunk driving problem. If you want to solve drunk driving, you put boots on the ground. You have roadblocks outside known drinking locations and on major routes and on the back roads. You know, countries which have done that have seen the results. AARTO is a different way of dealing with administrative type issues, of which drunk driving is not one, because drunk driving is not an infringement, it's an offense. If you are caught for drinking and driving, you go to court. It's not handled within the AARTO system. So there won't be very much impact from AARTO's point of view. So here again, we're talking about the difference between enforcement on the ground and administrative structures to support enforcement.
Okay, so we have a situation, I think we've dealt with the context, which is that we're going to have AARTO that is going to be implemented ostensibly on the 1st of July. That may obviously be a movable feast depending on what happens with various actions, legal actions. But let's for the moment assume that 1st of July arrives. We've dealt with the fact that in our minds, this is geared towards revenue collection and not dealing with road safety. But let's say it's coming on the 1st of July. What is the impact of the implementation of AARTO going to be on a practical level? If we look at the number of fines that are currently issued, Rob, throughout the country, what is the number of infringement notices, if we were to match that we could possibly see in terms of AARTO infringements being issued?
Well, let's start with the baseline. In 1998, in the entire country, 1.4 million fines were issued, and that includes notices for drinking and driving where there was a notice to appear in court or a summons or an arrest.
And that's not a huge figure, right? I mean, I think the point that you're trying to, it's not a huge figure.
No, not a big number. If you consider the number of drivers in the country and the length of our road network and all of the other factors, not huge.
Right.
Currently, according to the RTMC, it's about 500,000 notices a month being issued. So you're talking about 6 million annualized.
Right.
But the fact is that we don't really know how many notices these little municipalities, all 200 odd of them, are issuing around the country. So my feeling is that's probably understated. We might be closer to 8 or 10 million. But once we go national and once it becomes easier for the issuing authorities, the municipalities and the RTIA and people like SANRAL and so on to issue infringement notices, because it can now be done administratively via a computer system, we can expect that number to jump, I think. And there have been estimates floating around. I mean, the late Howard Dembowski at one stage said that he thought it might go to 14, 16, maybe even 20 million a year. So there's a substantial rise anticipated by most people who are looking at this.
So we look at that number of fines, and you are listening to AA Connect, the podcast of the Automobile Association. If you've just tuned in, or if you weren't aware that we were speaking to Mr. Rob Handfield-Jones, the MD of driving.co.za. Rob, we've spoken now. Let's take this base number of 10 million infringement notices. Okay, let's we don't double that for the moment. You've got 10 million infringement notices. I receive an infringement notice. Let's say 10% of the people that receive these infringement notices, in other words, 1 million people, say, hang on a second, I don't think that I've committed this offense. I think that I've been unfairly treated and I want to challenge this. I want to contest it. What is the process with that?
Okay. Again, to establish a baseline, let's talk about what the process is now under the criminal justice system, and it's very straightforward. If you get a fine you don't agree with, you say that wasn't me driving the vehicle, or it's not my vehicle, or I contest that this piece of legislation under which I've been charged is constitutional and I wish to have it struck down. You do what anybody does in a legal situation. You go to your lawyer, you challenge it at the magistrate's court, and you can appeal that decision all the way up to the constitutional court if you want to.
Right.
That's going to be changed completely under AARTO. What's going to happen to start with, if you disagree with an infringement notice for whatever reason, is you will be able to make a representation and you will fill in a form. The form will be submitted to the Road Traffic Infringement Agency. One of their representations officers will look at it, and then they will tell you whether your representation has been successful.
And will it cost you anything to go through that process?
Correct, yeah. So there is a defined process, and that's been in AARTO since the very first draft of the AARTO Act.
Right.
If you disagree with that, previously, then you had the option to be tried in court and say, no, I want to go back into the criminal justice system. I want to have my day in court. That has, to all intents and purposes, been removed from the current draft of AARTO. Now, instead, you will go to an appeals tribunal, which will then consider your case. And this is where it gets interesting, because we start getting into the numbers you mentioned. You know, putting 1 million people through the criminal justice system is not as difficult as it sounds, although every year there are only about 200,000 criminal cases that go through. But the fact is you've got access to that because there are 700 odd magistrates courts around the country. There's probably one close to where you live. So it's not a huge imposition for you to go and actually fight this in the criminal courts if you choose to.
Right.
But now you have one appeals tribunal handling 1 million notices a year. You start seeing the problem stacking up. There's a capacity problem.
But it's a huge tribunal, Rob, surely. I mean, it's a tribunal that's got hundreds of members on it.
Well, it has 9 members.
Wow.
I did some calculations based on my own estimates of how many cases this tribunal would be facing. And I worked out that they would have to conclude one case every 25 seconds. Now, in nobody's book can that be regarded as fair justice. So that is the problem with the appeals tribunal. They don't have the capacity. So your example of 1 million challenges to those 10 million notices is going to present a very major problem for justice.
And I think just on this issue of the appeals tribunal, there are 2 things that we need to highlight on this issue. The first is that the 9 members are part-time members, so they're not full-time members dealing with these notices. That's the first issue. The second issue is that they are not allowed via, in terms of the regulations, to assign or to devolve their powers as members of that tribunal to anybody else. Am I correct?
Yeah, you are correct, but there are 2 more issues there.
Yeah.
Firstly, the appeals tribunal is housed within the Road Traffic Infringement Agency. So
okay.
The fox is guarding the chicken coop. You're not going to get a fair and impartial hearing without any apprehension of bias as you would in the magistrate's court. But more concerningly, and this is a point that I've raised repeatedly, in the new Amendment Act, provision is made for the appeals tribunal to determine its own procedures. And that sounds very innocuous until you realize that that is the core of the tribunal. The tribunal can determine for itself how it will hear cases, whether witnesses will be allowed, what the qualifications will be, what the costs will be. I mean, if you have somebody who lives in Oudtshoorn and the tribunal sits in Pretoria, who's going to pay the costs for them to go and challenge that? Is that going to be loaded on them now? More importantly, these things are not cast in stone. So because the appeals tribunal can determine its own procedures, there's nothing to say that those procedures can't change from year to year. So if you commit a violation and you take it to the tribunal in 1 year and you are adjudicated under certain rules, what's going to happen the next year when the rules change? So there becomes an inconsistency in the administration of justice. And that, for me, is one of the most concerning aspects of the tribunal. It's really, one hesitates to go as far as saying kangaroo court, but it has all the implications and hallmarks of that kind of justice system.
So let's talk about that for a second, because I think you've touched on a very important issue, and you've mentioned this word in a few times in the past, Rob, and that is capacity. And I know that, again, this is an issue that you and I have spoken about at length, not only in terms of the capacity of the tribunal, which I think we are very much in doubt at the moment, just because of the volumes and the numbers of people who are involved. But do the municipalities, does the system that is going to be issuing the infringement notices, does the process of AARTO, is that capacitated? And I hate to use that word, but does the system have the capacity to deal with AARTO? Does NATIS have the capacity to deal with AARTO? Does the Road Traffic Infringement Agency, the RTIA, which is going to administer AARTO, does that have the capacity? Do we have the IT background, the IT backbone? Is all of that structure in place? Are we ready for AARTO is what I'm basically asking.
Well, the short answer is nobody knows. And this is an issue which has been raised since 2008. I went to a meeting in 2008 with people who were seized with dealing with that very issue. And at that point, they couldn't tell me exactly how it was going to work. Because we're talking about a completely new way of enforcing traffic law. And this applies to the traffic officers as well, because one of the problems, as we know in South Africa, is corruption and bribery. And what was planned at that stage was that each traffic officer would have a terminal in their possession. So if they alleged at the roadside that somebody had committed an offense, they would record that literally before the vehicle had even stopped and the driver had stepped out of the car. So from that point, there's no way back. You can't pay a bribe. You can't allege that you weren't driving your vehicle because it's captured on the system by automatic number plate recognition. So that was going to be a means of cutting bribery out of the system. So one of the questions is, what's happening about those terminals? What's happening about the IT systems to support them? If they work on SIM cards, is a contract for the SIM cards in existence? If so, who's paying the bill? Who's responsible for ensuring that those SIM cards stay current so that the traffic officers can do their job? At the municipality, who's responsible for reviewing the suspect infringement notices? How will they relate to the RTI? You see the questions that I'm asking, and I could keep on asking these questions. And the big question that comes out of it is the question that you've asked. Is the Department of Transport making sure that the Road Traffic Management Corporation and the Road Traffic Infringement Agencies and the municipalities are ready to roll this out? It has been one of the reasons given for the delays, the many delays to the rollout of AARTO in the past. Has that changed? I don't think anybody knows.
I want to just move just to the side for a moment, if you don't mind, Rob, because one of the questions that I actually forgot to ask you earlier, and I think it's a very pertinent question to ask, and this, I think, relates to the whole implementation of AARTO. If I am a fleet manager or I own a fleet of vehicles and I've got different people driving for me, how is AARTO going to impact on me as the person who owns that fleet?
Well, that's a great question, because there have been some changes to how that's going to be dealt with. Previously, there were only two categories of infringers recognized under AARTO. In other words, a private individual, you and I with a driving license, and a so-called operator. Now, an operator, without getting into the technicalities, basically anybody who has a business where they own a vehicle which weighs more than 3,500 kilograms, in other words, heavy vehicles, is an operator. And they have to have an operator card, and each vehicle has to have an operator card, and so it goes on. But there was a missing middle. What about a small businessman, a plumber, or a company with only two or three vehicles, which is not an operator? They own buckies or little trucks falling under 3,500 kilograms. They fell through the net. And the one thing I do like in the 2019 amendment to the AARTO Act is there's now been provision made for them, where those vehicles will now have points added to their registration number. And if you sell the vehicle, you can't get out of your points that way, because then what happens is when you next buy a new vehicle, the points automatically get added to the next vehicle. So I think that's a great system, and I think the government did right in closing that gap. So from a corporate's point of view, or even a small business's point of view, they are going to be affected by AARTO. They're going to have to keep track of how many points each vehicle or driver has got, who their habitual infringers are, and also simply from an operational point of view. If you've got a hotshot sales manager, and this guy turns over 10 or 12 million in sales more than his nearest competitor, you cannot afford to have that guy have his license suspended under AARTO because you've lost your best salesperson. What's he going to do? Take an Uber or a taxi to wherever he needs to go? That's just not practical. It's going to force companies to be a lot more proactive about how they deal with traffic violations, not only in the management of traffic violations, because that's well established. Most companies have got people in place, and the bigger one, operators have got a proxy, but also in terms of preventing traffic violations by making their staff safer on the roads so that they don't get into these tangles of having people's licenses suspended. So yeah, definitely big impacts coming for companies big and small.
Good. You're listening to AA Connect, the podcast of the Automobile Association. My name is Layton Beard, and I'm the spokesperson of the AA, and I'm joined in this edition of AA Connect by Mr. Rob Handfield-Jones, the Managing Director of driving.co.za. Rob, we've sketched a picture here. We've got a problem with the legislation as it is at the moment. There are provisions that we think are geared more towards revenue collection than they are towards promoting road safety. We've sketched a picture that there is a capacity problem, or there is a potential capacity problem with the rollout of AARTO. It may not necessarily happen on the 1st of July, but government is saying that it is going to happen on the 1st of July. If you had to give a message to a motorist about what the impact of this is going to have on them, what would you tell them?
Well, there were two types of motorists I'd be talking to. The first, the law-abiding motorists, I'd say no change.
Yeah.
The second is probably that your life is going to become a little bit more difficult if AARTO is enforced strictly. Because remember that you have 15 demerit points, and by the time you lose 16, then your license is suspended for 3 months for every point over the 15 limit. So you can't drive for 3 months, and you're going to have to make alternate plans, and that's going to be inconvenient and expensive. So there's going to be a motivation for people who are not law-abiding to become so. And remember, if you're caught driving on a suspended license under AARTO, then you go straight into the criminal justice system. And I speak under correction here, but I think it's up to a 2-year term of imprisonment. So there is a motivation for not continuing to drive, even if you think you won't be caught after suspension. So the message overall is nothing has changed in terms of the violations you can commit. What's changed is the way they're going to be enforced. And it's up to each motorist. You know, if you've passed the driving test, you should know what to do. And you can either do it or choose not to and face the consequences.
And I think you've touched on another important issue that I think that we should also just land on for the moment. You talk of the 15 demerit points, and when you look at some of the provisions in the schedules, Rob, you know, if you fail to stop, you know, behind the white line at a stop street, you get 3 demerit points. If you speed, you get, you know, let's say 4 demerit points. I forget what the amount is. It's actually going to take you some time to get to the 15, and after a period of time, you regain those demerit points back again. So, you know, after 3 months, if you had 3 demerit points you got in January, by the time April rolls around, you've got those 3 demerit points back again. So you're almost back to square one. Is 15 too much? Why, if we want to promote road safety, didn't we make it 9?
Well, if you go and look around the world, there are all sorts of different limits for demerit points. And the original proposal in AARTO was 12. It was extended to 15 in the 2019 amendments. You know, the whole purpose of AARTO is to deal with habitual offenders. We want the guys who repeatedly commit traffic violations to go into the AARTO system and potentially have their licenses suspended. Because remember that most traffic crashes are preceded by a traffic violation. That's uncontroversial. It's been known for decades. So if we can target the people who commit more traffic violations, then we are going to create an incremental improvement in road safety. So I think from that point of view, that's where we should be looking at those specific habitual offenders. And I don't think 15 is too many. I'd prefer 12, but 15 is also good, because if somebody's a habitual offender, it's not going to take them long to lose 15 points. If you look at, you only have to go through 6 or 7 stop streets without stopping, and bang, there's your 15 gone. But it comes back to something we talked about earlier. Where is the enforcement to make this happen? Because if you can commit violations with impunity in the knowledge or the belief that you're not going to be caught, well, then
you're going to carry on doing it.
As a habitual infringer.
Yeah. Are we going to see it implemented on the 1st of July, Rob? What's your take on that?
I would be surprised. There was so much that needed to be done. I mentioned some of the issues in terms of capacity at the municipalities and ensuring that the technological support for the traffic officers rolled out. We've heard nothing out of the Department of Transport which might indicate that we're on our way. So the short answer is I don't think so. And even if we are, I suspect there are going to be court challenges. The Western Cape government, for instance, has said for years that the moment AARTO is rolled out nationally, it's going to challenge it. I'm not sure what the grounds are going to be, but if they challenge it and when they file their papers, we are going to find out. And there are also private bodies like AARTO that have said they're going to challenge the legality of AARTO as a whole, which will be an interesting case to watch. So it might be that the system is rolled out and then interdicted immediately pending court challenges. I don't know, but it's going to be a fun game to watch.
Yeah. And in the meantime, sadly, we're still going to have carnage on our roads. We're still going to have people who are involved in crashes. And those figures, I don't think, are necessarily going to come down, in certainly not in the short to medium term.
Well, if we couldn't deter people from committing traffic violations with the threat of a prison sentence, how is the threat of an enforcement order going to change that? And I want to come right back to what you said about silver bullets earlier. If we want to really make a big difference and create big impact on our traffic safety scenario in a very short time, then what we've got to do is look at the source of the problem. And the source of the problem is actually neither enforcement nor the differentiation between administrative approaches to traffic enforcement or criminal approaches to traffic enforcement. It is licensing corruption. Every time the Special Investigating Unit has looked into this issue, they have found that around 50% of the licenses under investigation were fraudulent. In other words, bought, forged, or illegal. That's the problem we need to fix, because if we can keep incompetent drivers off the road, we won't have to worry about how we enforce their traffic violations at all.
Wow, powerful way to end. Thank you. And on that note, Rob, I'd like to thank you very much for joining us on AA Connect, the podcast of the Automobile Association of South Africa. I think this has been an incredibly useful conversation, and anybody who listens to it or watches it on YouTube will have a little bit more understanding of where we are and where we came from in terms of AARTO. So thank you very much, Rob. I appreciate your time. And to anybody who's watched this or is listening to this on a podcast, thank you for your time. Until next time, this is Layton Beard signing off. Thank you very much. Goodbye.